There's still a few joining, but I think we might kick off now. So hello everybody, and thanks for joining us today. Thanks for taking the time out of your day, we appreciate it. We really hope you get some value out of today's session. So my name's Jonathan Teeple, I'm a director here at Quantum Advisory, and I've got the privilege today of being joined by two wonderful ladies from EmploySure. That's Lizzie Morrison and Gwen Espy. So a bit of an introduction to Gwen and Lizzie. So Gwen is a business partner with EmploySure. She has over 20 years of experience with all aspects of HR and employer relations. And she has a real passion about helping Australian businesses to navigate the complex employment law landscape. And we've got Lizzie here as well. She's a business development manager with EmploySure, and she's helped hundreds and hundreds of businesses get HR compliant and put the headache of HR behind them forever. So very warm welcome. Thank you very much for joining us.
Thank you.
I've got Lizzie in the office with me today, and Gwen is joining us from sunny Tasmania, while the rest of us fight the rain. So lucky you, Gwen.
It's nice to be on the opposite side for once, not having the rain.
Okay, so we've had a lot of interest in this webinar, and I think it shows the level of concern out there at the moment around HR generally. Obviously with COVID, there's been a lot going on. There's a lot of concern out there as to remaining compliant. With some of the marketing we did for this webinar, we shared some pretty scary statistics that were in place prior to COVID. And I think COVID's really only going to escalate those in terms of some of the tensions that are obviously building in the workplace with a lot of uncertainty and things like that. So we've got a lot of different businesses, in a lot of different areas on today's webinar. Some down your way, Gwen, in Tassie, some in Victoria. Shout out to them. They're obviously going through a really tough patch at the moment. So really hope you get some clarity from this. And I'd first just like to start with a challenge to everyone on this session today, to take a really good assessment of how things are right now internally in the business in terms of HR relations. There's some really sort of dismal statistics out there. We don't want to kind of dwell on that, but there's currently 920,000 businesses enrolled for JobKeeper. There's over 3.5 million employees on JobKeeper, representing about 30% of the pre-COVID workforce. We've got the unemployment rate currently sitting around 7.4. 6% is normally what economists would call a recession. And a recent study by Seek said that employee job security was the lowest it's ever been. And I guess take a lot of innovation and technology in the workplace, add something like COVID, and all of a sudden people are very insecure. So I guess we're in a situation at the moment where we've got a lot of employee insecurity on one side. They're wanting to provide for themselves and their families. They're worried about their financial future. On the other side, you've got businesses that are having to make tough commercial decisions around, and they're closely analysing their numbers, looking at the return on investment on everything, including people. They're looking at pivoting, cutting costs, what they can do differently. And I think one thing we are seeing when we've sort of taken soundings around our own client base is there is a little bit, unfortunately, there's a little bit of a sort of negative cultural us and them shift happening, which businesses put a lot of effort into breaking down in the past. So I guess the main message out there today is that level of insecurity is out there. So if it's something you're experiencing in your own business, if we can say anything, that is get compliant. The last thing any business that's already been hit by COVID needs is some massive, complex, legal, expensive HR issue. So get compliant. Obviously, we've done a lot of work with EmploySure, and we say there's two types of businesses out there. That's businesses that are using EmploySure and businesses that have never heard about EmploySure. So you might hear a bit later about how they work, but I think with that we should jump straight into the meaty stuff. So one thing I just want to touch on very briefly before I hand over to Gwen to really get stuck into this is just the changes with JobKeeper 2.0. So so I'm not going to go into this in a lot of detail. We will be sharing this information with anyone that's attended today. I guess the main difference, or the main thing to point up is if you're in, you're in. So you'll be in until September. And then after that, it's looking at the same decline in turnover test, but over a quarter-on-quarter basis compared to the comparative periods. So I guess they're, in a way, they're really cutting out anybody that's just had some sort of peaks and troughs in their sales activity, and looking at businesses that have genuinely been affected. There's also some new employee eligibility tests based on hours, so 20 hours above and below, and then that's being scaled back. Is this a good initiative? Definitely. As I said, it's definitely helping business at the moment, and I think the new tests that are put in place will be sort of sorting the sheep from the goats, so to speak, as to who's truly eligible. The flip side is that I think the recovery curve for a lot of industries is going to look differently. So there are some businesses that may not have yet been eligible that are still yet to feel the hit, potentially after JobKeeper's over. So I guess time will only tell there. But anyway, with that, I know Gwen's got a mountain of exciting, cool stuff to get through. So I'm going to hand over to you, Gwen.
Awesome. Thanks, Jonathan. As Jonathan said, my name's Gwen Espy. I'm down here in Launceston today, where I have been what feels like under house arrest for the last 4 months, working predominantly from home, but thank goodness for Zoom and other such platforms. So as Jonathan said, we've got a fairly lengthy amount of information to share with you, just to give you some support and some knowledge going into this new financial year. So going to touch on some of the stuff that you might need to be aware of. I mean, there's always changes come new financial year, and obviously with the added challenge of COVID, there's some additional things to be aware of and think about. Going to spend a little bit of time on hygiene and safety specific to returning your employees to the workplace and or having them in the workplace with this COVID crisis. And I guess particularly if, thinking of Victoria and some of these areas in New South Wales that are starting to show issues, what exactly that might look like. And then two of the hot topics in industrial relations at the moment is around annualised salaries. So we want to touch on what that actually means. And Fair Work have done some work over the last 12 months and made some changes about how to manage your employees if you're paying them an annual salary rather than an hourly rate. And then the other one we want to have a look at is engaging casuals. And those of you who've got casuals in your workforce, you'd be aware that recently there was a court decision which really turned a lot of businesses on their heads in terms of what you think about and how you manage your casuals. So we'll talk about that. That number 5 there, managing employees, really just want to touch on, I guess, one of the key issues facing all businesses and business owners across Australia, but particularly small businesses, and that is the spectre of unfair dismissal. So what is it? How can you avoid it? And who has the entitlement to lodge an unfair dismissal claim? So I'll have a little bit of a look at that as well. And a slight bit of housekeeping. You'll see, hopefully, on your screen somewhere, there's a Q&A box. So please, I don't have the pleasure of seeing your faces, the people that I'm talking to, but if you've got questions, please feel free to pop them up there in that Q&A section at any time during this presentation. I'll sort of stop a couple of times, take a breath and have a look at those questions and answer a few as we go. And then at the end, I will go back and try and cover across as many questions as possible. If we do run out of time, I will certainly come back to you with an answer by email regardless. So you'll definitely get your question answered. So please feel free to throw any questions you have in there. Let's jump in. Jonathan, can we have that first slide? So here's poor sniffly Steve here. So one of the big things on the Fair Work calendar every year is the 1st of July minimum wage increase. So in Australia, you'd be aware we have a minimum wage for an adult employee. Now this year, we have since received information about that increase. Many of us had been hoping that Fair Work would make the decision to delay any increase this year. They have that power in exceptional circumstances. So many of us were hoping that they would either freeze it and not change it at all this financial year, or look at it later this year or early next year. Due to the crisis that we're in. Now, not surprisingly, the ACTU were on the opposite side of that argument, and they were pushing for a 4% increase across the board. So you'll be aware now what's happened is we have got a 1.75% increase to the national minimum wage, but instead of that being across the board, there's a staggered according to your award. So there were some awards that have already had to take that increase and pass it on to their employees where relevant. There's another group of awards that will come on the 1st of November. And then the third group, which Fair Work have identified at this stage, have been most impacted by the COVID crisis, will be on or around the 1st of February. Over the next slide, Jonathan. Now, Mr. Morrison's quite a fan of the old job maker, job keeper, job seeker words. So I'm not sure who's coming up with these for him. So we're all familiar with job seeker, very familiar with job keeper, I'm sure. And there's a third, I guess, prong to the Prime Minister's plan to help us, you know, as a nation come out of this financial mess that COVID has given us, and that's job maker. So what that is essentially a quite a what's the word I'm looking for? Complex working groups, 5 of them all together, that will be looking at simplifying awards, organising enterprise agreements, and making sure that all employees are paid properly. And that's a really big scope of information, huge scope. But ideally what it's looking to do is improve, I guess, that relationship between employees and employers, although, you know, the groups at large, and also make some improvements toward our skills and training systems that we have. Those of you who may engage apprentices or trainees will know that it, along with everything else in our employment law and employment system, it's very complex and multifaceted and lots of different fingers in the pie. So that's the plan. If the only thing that comes out of that is a simplification of the awards, I think that would be a huge win for many small business owners particularly, because at the moment, if any of you have had the pleasure of reading an award, you will probably accept my belief that they're written by psychopaths designed purely to drive us insane, because they are so written in such a way as to be quite confusing and difficult to read and to make sure that you're interpreting them correctly. Let's jump on, Jonathan. So this was the roadmap that the federal government presented us with to get, you know, to a safe, from a COVID perspective, when we first came out of sort of that hard lockdown. Step 1, step 2, step 3. Now, different states have implemented this differently, as was expected and required. And as we all know, and, you know, huge shout out to any of our Victorian employers watching and joining us today. Victoria's had, or parts of Victoria have had to step right back, even past, in some stages, that's step 1. Other states, I'm in Tassie, the joy of being an island, we've been able to shut the door and not let anyone in pretty much. And so we are definitely at step 3 and beyond, and other states similar. But of course, these, you know, they're very flexible in terms of coming and going. But what that meant was different businesses were opening back up their workplaces and bringing their employees back. So some of you would have been bringing your employees back from stand down. So your business was completely closed due to government requirements. And then now you've been allowed to open the doors again. So what does that mean? For others, it might have been returning your employees back to from working at home. So like myself and most of Employsure's employees, we were deployed to work from home some months ago. So it's getting them back into the office or back into the workplace. And what does that look like? So let's have a look at the next slide, as that'll talk to us a little bit more about hygiene and safety. We'll just click on another one, Jonathan. So in terms of moving forward while still, obviously managing your business in this COVID pandemic, there are some things you need to be aware of about, what are my requirements, what are my obligations, how do I make my business as COVID safe as possible. The one that I'm dealing with relatively regularly at the moment with some of our clients here at EmploySure is that number 1, 2, 3, 4 there. My employee is refusing to return to work. What do I do? So we're going to come to that in a second, but let's just click on, we'll have a look at what you need to do in terms of starting to have a look and make sure your workplace is COVID safe. If we can get that next one, Jonathan. So essentially what you're needing to do is a risk assessment process. Now, most of you will be familiar with some level of risk assessment from a work health safety perspective that you've already been doing, not related to COVID. So before you can open again or bring your employees back, if that's still the situation that you're in, is having a look at is the workplace as safe as it can be from a COVID-related perspective? And what is the likelihood that COVID could be transmitted in my workplace? And then second, if it was transmitted, how serious would those consequences be? Now, the answers to those questions are going to be different depending on your industry and your type of business and how you work and how your employees work. And then, so once you've done that assessment, so you've said, okay, this is the likelihood, this is what the consequences could be if one of my employees was to be infected with COVID or infect others, and then you put measures in place to either eliminate that risk so far as you can. And obviously one of the classic ones there is not having any employees in the workplace is an elimination of that risk because you've got them working from home, or just minimise the risks as much as possible. So if we click onto that next slide again, it's one of the easiest and most important and critical obligations you've got in terms of reducing and or minimising, or completely eliminating the risk is to provide hand sanitizer. I don't know about you, but my hands have aged about 35 years in this COVID crisis, having to be washing them every time you move and putting hand sanitizer on every time you step into a new room or a new building or workplace. But that is an absolute critical. You do have an obligation to provide hand sanitizer and good antibacterial hand wash, in the bathrooms, around sinks, wherever that, hand washing processes may take place. And also have, some posters, you can get them. There's some really good posters on WorkSafe Australia and WorkSafe state sites or Safe Work, depending on your state, with a hand washing poster, really showing and identifying the correct technique for washing hands. Who knew pre-March or February that pretty much none of us wash our hands properly, but that old 20-second technique. And the further to that around, other personal protective equipment or PPE, as we might call it, things like gloves, masks, eye shields, gowns, all of that will come down to the nature of your workplace, except if you're in Victoria or certain areas of Victoria right now. If you're having your employees come to work because, that's the only option that you've got right now, and you've done that assessment and that's the best, they can't work elsewhere and you are an essential service or whatever it might be, you would need to be providing your employees face masks to come into the workplace. In other areas, if it would depend on the job that they're doing, whether or not they needed masks, but in Victoria, given those specific areas where it's been mandated, you really do need to be providing them for your employees once they're at work. Click on next one. Some of you, from what I understand, if we just flick back one, would have employees who work off-site. Someone like me, while I am predominantly under house arrest, as I said, I do, particularly in the last 6 weeks as things have started to ease up, actually go to site and see our clients here in Tassie. Obviously haven't been flying anywhere of recent times. But if you're sending your employees to another site other than yours, whether it's because they're a delivery driver, if they're, employees that work in the field like myself, building, construction, anything like that, you have to be as certain as your own workplace that workplace is safe, that site is safe for your employees to be. So again, you need to do or have done, whether it's by your employees, a risk assessment to say that they that third-party site is following the same level of safety as you are, and providing that level of safety to your employees. If you are unable to ascertain that, then you need to make the decision for the employees to not be involved in work on that site, and until such time as that can be improved. So, for example, here at EmploySure, when I do go to site, now I don't book my own diary, but the lovely people who look after my bookings would actually be calling that employer or sending an email requesting information about their COVID safe workplace practices. So is there hand sanitizer? Are there masks? Can I keep a distance from other employees on site? That kind of stuff. Alrighty, let's kick on. I think we're going to go to the next annualised salaries. This is where I'd love to be able to see a hands up, but annualised salaries there have been changes made by Fair Work into a number of modern awards, not all of them, but a number of them, that came into effect after the 1st of March, the first full pay period after the 1st of March. And the reason for that is that there was a concern, across, numerous industries that have been raised through cases and claims and what have you, that people on annual salaries in many circumstances may have been at risk of being underpaid because, they might have agreed, if we just use a figure of $50,000 a year, but then they may be working, 45 hours a week, occasional weekend, public holiday, whatever it might be. And when that was then broken back to an hourly rate, it was actually less than what they should have been paid under the award. So if we click onto that next slide, it'll give us a little bit more information. So this is what you need to do if you are affected by one of those awards. So have a look, first of all, at your award and does it have information in there that says about an annualised salary? And that you need to then advise your employees how you are going to actually calculate their annual salary. And what you need to then have worked out, well, what are the outer limits of this salary that I'm giving this employee? So if we go back to our $50,000 a year employee, you've done a calculation that says on average, this person's going to work 40 hours a week. Occasionally, due to particularly busy times during the year that we can identify, they may work, 43, 44 hours a week. And you're also putting in there their annual leave loading and any other allowances that they might be entitled to. And then where that in a particular week it falls outside of that, you need to pay them those additional hours as overtime. And one of the other very new things that this annualised salary requirement has put in place is that those employees, even though they're on an annual salary, they need to record their start and finish times, including their breaks, so their meal break. So they start at 9, let's say, they finish at 12, have a break, start back at 12:30, finish at 5, whatever it might be. And that needs to be recorded and signed by your employee each pay period. And then every year you need to do a reconciliation and make sure that what the employee was paid is at least what they would have received under the award if they'd just been paid an hourly rate plus their overtime and allowances and so forth. And if there is an underpayment, so if they've been paid less than what they should have been under the award, you then need to pay them the difference within 14 days of that being identified. So that's new, only in some awards. So check your award. Many of you will be covered by an award, and there's so many different awards, but go in, check your award, have a look, does it say anything about an annualised salary and when did it come into effect? I think there's one more screen on that I'll just quickly talk to.
If I can just jump in there, Gwen, is it right that one of those awards that covers is the clerical award?
Off the top of my head, I'm going to say yes, the clerical awards is definitely one of those. So if you've got any admin staff, that they're going to be covered. They're going to be affected by that. Yeah, absolutely.
For sure, we had 300 staff that fell under that clerical award. So we now have 300 staff that work in our offices that are recording their time, start time, finish time. All of this is, begun a few months ago for Employ Sure. It's incredibly labour intensive. It's a huge load on employers, that wasn't there pre-March when this started. So it's a tough one.
It's a big change. It's a big change. Okay, let's kick through to the casual question or issue. This one has also probably been top of mind for many of you. Again, I'd love to see your hands. But there was a court ruling. If we just go to that next slide, there was a court ruling in, I want to say May, which shot a bit of a shot, set a shot across the bow of many of us who engage casuals. So there was a full federal court confirmed that this employee, Mr. Rosato, even though he'd worked as a casual for a number of years, because he was working regular and systematic hours with predictable periods of working time, he was in fact a permanent employee, and therefore he had to be paid annual leave, sick leave, compassionate leave, public holidays, everything that he should have received if had he been a permanent employee all that time. So if you engage casual employees, this has the potential to impact you as an employer. And what we need to do as employers is have a look at how we engage our casual employees to try and determine whether they're true casuals or whether they're permanent, or potentially be viewed by Fair Work as permanent, should they take a claim to Fair Work. So if we jump into that next one, Jonathan, if I was going to break it down into what is a casual and what is a permanent, a true, if we'll go permanent first. If they are going to be working for you on an ongoing basis, every week you want them for say 20 hours, 25 hours, sometimes you might need them for a few more hours, really that is a permanent employee. On the other hand, if they are just filling a gap, because you've had an increase in workload temporarily due to something, or you just need someone to come in and plug up a hole each time someone's on annual leave or sick leave or what have you. I guess a teacher, a casual teacher is a really obvious one there. They're sitting by the phone waiting for the phone call each day to say, hey, we've got a sick English teacher, come on in. If it is that you are somewhere between the middle of those two and employees are casual, you've got them engaged as casual in terms of their contract, but they know that they're going to have work on an ongoing basis. They don't expect just to work this week. They expect that they will have hours next week and the week after, and they know roughly how many those hours will be, and often times what that pattern will look like for hours. It's more likely to be considered a permanent arrangement, and therefore put you at risk of claims to Fair Work for payment of those things like annual leave and sick leave and so forth. So if we jump onto the next one, so have a look at your employees. If you've got casuals, a couple of things. Have a look in again, in each of your awards, there was something put into each award, I'm going to say probably about 18 months ago now, which talked about converting your employees from casual to permanent. And it actually says that once your casual has been with you for either 6 or 12 months, and different awards will say different things. So if we go for the Clerks Award, that says 6 months, you must tell them that they have the right to request to convert to permanent, and record that in writing that you've told them that. And then if they say, no, look, I'm really happy being a casual, thanks very much, I'll take my 25% extra pay, don't want to be permanent, record that as well in writing so that you've got that added protection. And then make sure that any loading, so that 25% loading is very clear in their contract that they're receiving that. in lieu of annual leave and personal leave. And similarly, it's clear in the payslip that they're receiving, you know, $20 an hour as a restaurant worker, and you know, $5 an hour as the casual loading for that position as well. Please, as I said, jump in and ask, pop some questions in there if you can. I'm conscious of time, and so we'll just keep running through. There's a couple of questions there, but because we'll just leave them to the end. Jonathan, if you want to jump through to the next one. I'm getting ahead of myself. I just talked to that one. So, unfair dismissal. This is where I play a lot of my day, not in unfair dismissals, but in helping our clients actually managing the risks around unfair dismissal and employee behaviour, you know, misconduct and so forth. In the normal world, when I'm flying to and from Melbourne on a very regular basis, my husband refers to me as the flying assassin, which is very unkind, but that's because I'm supporting our clients through these challenging conversations. So we might just flick onto the next screen, Jonathan, if I could. So I want to have a look. So you've got a few different risks, but I really would just want to focus on unfair dismissal and adverse action. Bullying and harassment is a whole other couple of hours of talk. So unfair dismissal, if we just flick onto that one, we should have a screen. In order for a dismissal to be deemed unfair, it has to, to be deemed fair, I should say, it has to be for a valid reason. So you have to be able to show there's been poor performance or misconduct, so bad behaviour. You can't any longer, you know, gone are the days when we could just, you know, get rid of someone because we needed to downsize, or we just, you know, have a feeling they weren't, you know, doing a good job. We actually have to run through a process and have to show that it's valid. Certain employees are protected from unfair dismissal, and this is important to know, because you've got a space of time when you first engage an employee to be able to move them out of your business without running the risk of unfair dismissal. So a couple of things. If you're an employer who has 14 employees or less, your employees don't have access to unfair dismissal until they have been with you for 12 months. So effectively, up until that point, you can dismiss them without the risk of an unfair dismissal claim. If you've got 15 or more employees, you've only got 6 months to do that. So I encourage all my clients, use your probation for what it's designed for. Check that employee out. Are they doing the job that you want them to do? Do you think they are going to be able to, you know, get to where you need them to be? Are they showing you any signs of things that you might be concerned about? Having excessive days off, you know, sick leave and so forth. You know, that may feel a little bit non-genuine, because if someone, my experience is, if someone is misbehaving or doing something you're not quite comfortable with in the probation period, that's just going to get worse once they are safe on the other side of probation. So once they have reached that probation period, so either 6 months or 12 months, depending on the size of your business, they then have access to unfair dismissal. And particularly now, we are seeing, since COVID and people obviously being in, what's the word I'm looking for? Self-preservation mode, unfair dismissal claims are going through the roof. We have had to staff up our legal firm. We have our in-house legal firm. We've had to staff that up with a lot more employees to cover the unfair dismissal claims that are coming through, not because employers are doing anything wrong, but because employees are being more litigious around a dismissal. And it's really easy to lodge an unfair dismissal claim. There's a fee, I want to say $70 that they have to lodge, to pay to lodge their claim. And that is as hard as it gets for the employee, and they just have to provide some details. Now, even if their claim turns out to be utterly frivolous and have no basis in fact or reason, there's no consequence. You've then got to deal with that unfair dismissal claim regardless. So I could certainly go through a lot of information about how to avoid a claim, but it's my two main points to you, or my two main bits of advice would be: use your probation period really well and follow a process in terms of if you're going to look at terminating them to avoid that unfair dismissal claim. So make sure you have meetings with them and provide written warnings and so forth. Get advice, you know, from someone who may know. And that's very much what we do at Employ Sure. Our advice line's 24/7 for our employers, our clients. They ring and say, you know, Gwen's misbehaved. She hasn't turned up for work for 3 days in a row. What do? We just want to sack her. And we can say, you can't sack her, not just yet. Hold fire. Let's do this first and step through that process. We might just skip ahead a couple of screens, I reckon, Jonathan, if you just, yeah, keep going that one. We'll skip over that one. So my lovely marketing person put in a whole heap of screens there that we probably don't really want to cover just because of time, and it's a whole other seminar really. But in terms of mitigating your risks, make sure you've set your expectations very clearly and the boundaries that you are prepared to allow your employees to work within. And make sure that you follow through and that you expect compliance with your policies and that you then follow those through each and every time. Let's jump on to the next one. Jonathan? Yeah, we'll keep just going to there. And the other thing I just wanted to cover is, you know, in terms of post-termination or once you have dismissed someone or they have left your business, is exclusion. So some of you may have some information in your contracts or would like to put information in your contracts that says certain employees can't do certain things. And after they leave, so they can't set up a business, for example, they can't go and work for a competitor, you know, can't solicit your client base, that sort of thing. Now, they are really important components to having a contract, and you can largely put whatever you want in there, as long as you are aware that it is really best only as a deterrent. They are very hard to enforce. If you've put something in that says, you know, for 12 months, for a radius of 50 kilometres around my business, you can't do the following things. You know, you can't work for a competitor, you can't set up your own business, you can't solicit my clients. You then have to go before a judge or a magistrate to get an injunction if you think that they are breaching that. And it's notoriously difficult to get one of those injunctions and costly for you. But they're an excellent deterrent to have as well. We just click through, yeah, we'll kick through a performance improvement plan there. Before I stop talking, give you a break from my voice, I'll I did see a question come up and I do want to answer this one before we go. Where did that question go? You know, in terms of employees who may not be on annual salaries, but you're paying them what I call a loaded rate or an inclusive rate, where you're paying them an hourly rate, but you're paying them everything inside that rate. Their annual leave loading, any allowances they might be entitled to, maybe their overtime. You, again, similar to annualised salaries, you may not have an award specific process that you have to follow, but you are liable to make sure that that person is still receiving what they would be normally entitled to if they were receiving, you know, their hourly rate plus their annual leave loading plus their tool allowance plus their site, you know, whatever it might be, you know, travel allowance and so forth, that when it's broken down across a period of time, they're at least receiving that minimum amount. Now that is really tricky to do. We have a wages team that calculate those for our clients because it is really hard to make sure that you get everything into that rate and don't risk an underpayment claim. An underpayment claim can come back to you for up to 6 years after that payment has been received. So, you know, not 2 weeks or 3 weeks later, but anything up to 6 years if an employee decides that they have been underpaid at any point. So I think that kind of brings us to the end of the information that I wanted to share with you. There's a lot in there, and I'll jump into the questions shortly, but I'm just going to hand over to Lizzie for a bit of a bit more talk about what we actually do at Employ Sure.
Thank you, Gwen. You can have a drink of water now. So Coke will do it as well. Thank you. I learn every time I listen to you, so that was fantastic. So in terms of employee services, if there's anything that anyone would like to ask outside this medium, I'm available for follow-up meetings. So with employee the way we engage with our clients, it's a 4-step process. It's quite simple. We start on that top left that says compliance. So we would review your business in terms of a gap analysis. We work with the gap analysis to the Fair Work Act or the Safe Work Act, depending on where your state is, and we bring you up to compliance. So we put the documents in place that you need to keep the government regulator happy, but we also give you the tools to manage your staff, which is a contract and an employee handbook. So once we've established that initial compliance, we then move on to 24/7 advice, as Gwen mentioned. So our advisors, anytime something pops up in the workplace, you give us a call, we'll talk you through how to handle it, but we'll also issue you our advice in writing. So if you need a memo to all staff to remind them of a no smoking policy, we'll give you that. If we need to help you with the termination process, we'll walk you through it and provide all the documents. And the reason we're so strict on providing written advice is we are setting you up with an audit trail in case there is a Fair Work claim. So if any of our clients get a Fair Work claim issued against their business, we partner with a law firm. So our lawyers step in and they handle the case from start to finish. So we do the legal representation, which is on the bottom right of your screen, but we also protect you from fines or any costs from that claim as well. So we're backing our advice. If we get to the Fair Work Commission and they say our advice was wrong, we pay the fines. So it's a 4-step process, and I'm more than happy to go into it with a little bit more detail if anyone wants to be followed up after the webinar.
You're probably just
questions.
Yeah, you've probably just seen a poll pop onto your screen there as well, everyone. And I just encourage everyone to jump on there. As said earlier, if you're not currently working with Employee Sure, which I understand there are a few are, then yeah, it'd be awesome to reach out to Lizzie. If nothing else, just get a little bit of advice.
Absolutely.
Just get that second opinion. She's very low pressure and very helpful. So yeah, there's a few rolling in now. Lizzie, so it looks like you're gonna have a busy few days. But yeah, I think I mean, yeah, just I'm gonna play devil's advocate here and sort of jump in behind your back and Gwen's back, but I mean, there obviously is a cost involved. The subscription-based model could cost a couple $100 a month, could be, you know, upwards from there, anything up to a couple of thousand based on employees. But yeah, we've seen a lot of things happen with a lot of different businesses, and the cost of not having this in place is scary. And I think it's just good at this, particularly in this current environment, if you've got that peace of mind that at least that paper trail's looked after. As Gwen was saying earlier, how easy it is to lodge a safe work claim. I jumped on the website the other day just to take a look.
$72, I think?
Yes, yeah, $70 something, and they've actually put a YouTube video on there telling you exactly how to do it, and even, you know, if it has to go to you know, if it has to go to hearing and everything, where you do, you know, what you have to do, what you have to say. They've made it very, very easy for people to cause trouble. So yeah, I'll be jumping on there. But yeah, it looks like quite a few have. So if you missed the opportunity on this poll, no problem at all. You can reach out to any of us at any time, and we can put you in touch. So we'll finish up the poll now, and we'll take questions, which there's a mountain of, Gwen. So let's jump headfirst in.
Lovely. Now, the first question is re JobKeeper. Can an employer receive JobKeeper and a 50% wage rebate for apprentices? I believe that it is possible, but I would definitely encourage you to just double check that with your accountant, depending on your particular business. Then there was a question there. What happens if you're under an award that does have annualised salary, but recently been changed to an award that does not have annualised salary? Then, you know, you don't need to, if you already have started complying with that annualised salary requirements, that's fine, but you don't need to maintain those reports going forward. You would still have those requirements, as I flagged toward the end of that our discussion, making sure they're still being paid what they should be, you know, under the award, but you don't have the requirement to keep all of those reports and signing off each week on the timesheets and so forth. 80's asked, are there any automation tools out there that makes recording and sign off easier? There are quite a few, from what I understand. Actually, Employ Shall have one in our repertoire of tools that's available. And in fact, we've just developed one for our own employees as well. I think, as Lizzie said, there's a huge number of our, particularly our office-based employees, that do actually fall under these annualised rules. So there are definitely lots of options out there. Because you don't want to be doing it manually. That's just a nightmare, isn't it? Now, Stuart, if we're under 15 employees, do we still need to give them written warnings within the 12-month probation period? The easy answer to that, Stuart, is no, you don't. It's always helpful to have some backup information in writing. You know, that you may have had some conversations and flagged some concerns about their behaviour or their performance while they're in that sort of protected time when they don't have unfair dismissal rights. But the thing to be aware of, which is a whole other facet, is while they don't have unfair dismissal rights, they do have what we call adverse action access from the very, well, in fact, before they've even started working for you. So you just need to be, with any employee that you're looking to dismiss, be mindful, is there anything about that employee that might be protected under law that they may hang their hat on to say, you are not sacking me because I'm doing a bad job, you're sacking me because of my, my religion, or my sexual orientation, or the fact that I'm pregnant, or any of those things that are protected under law as what's called a general, under general protection. So, so the easier answer is no. Oh, there's a question there, Gareth. What is adverse action? So adverse action, thank you, Gareth, is around, taking action against someone because of that protected. You may not be. But if they can can identify in any way that that is why they believe that they are being dismissed, then that can lead to an adverse action claim, and they are much more expensive. They are horrible. Where an unfair dismissal claim caps at 6 months, absolute outset, there's nothing more that they can claim. An adverse action claim, I've seen them for $60,000, $80,000, $100,000, where someone's, been able to prove that they were dealt with because of a particular protected identified factor. Now, there's a couple of questions here in the chat section as well. Let me just have a look. Do permanent employees need fixed day and hours? If they're varied from week to week, are they safe as casuals? Rod, depending on your award, but almost exclusively, so your permanent full-times are going to have 38 hours a week. And again, that's other than one award that I can think of off the top of my head, which is the Black Coal Award. That's what maximum they must work is 38. If they work beyond that, then they are eligible for overtime, notwithstanding what we just said about annualised salaries and so forth. If they are part-time, so therefore they're working under 38 hours, almost every award will say that you must put in their contract what hours they're working. So Monday, 1 to 5, Tuesday, 9 to 4, whatever it might be. And if that changes, then you need to get that in writing each time it changes. Otherwise, they are then eligible for overtime for every hour above. If they're varied from week to week, your question is, are they safe as casuals? The fact that they're working each week means that they're probably going to be deemed as regular and systematic. So you're still probably running. And look, the reason I can't say, look, absolutely certain, is that it is so grey. And that's part of the problem with our casual system and our laws around it. It is quite grey. But if they are working regular hours, doesn't matter if they're different numbers, you're probably going to run that risk of it being considered a permanent arrangement rather than a casual arrangement. Now, if I picked up all of those questions out of the chat,
I believe so.
Oh, there's just one. What's the latest for sole traders and partnerships as far as job maker, etc.? Job maker, we're still all waiting with bated breath as to what comes next. We haven't got a lot of detail. And job keeper, as you saw in that first slide that Jonathan shared, now none of that has passed through Parliament yet. So unless I've missed something, no, that hasn't passed through yet. So as you remember from, JobKeeper Mark 1, what was announced by the Prime Minister and what we saw come out the other end was there were some differences. So yeah, we'll just all have to keep waiting, and hopefully that will pass through Parliament fairly swiftly so businesses can start planning. So
I do just have a couple of questions, Gwen, that have been sent to me directly, with a few clients being on the call. So what can I do within my power to get an employer to return to the office who's constantly no-showing due to what I believe is a convenient fear of COVID-19?
And I'm sorry, I meant to answer that question. I've had a number of disciplinary meetings, which is one of the things I conduct for our clients with that very issue. So either an employee refusing to return from either being stood down, so that could be because they're getting JobKeeper. Yeah, I've actually had one employee say to me, "You can talk to me in September when JobKeeper finishes," with their hand up like this at me. If they are refusing to return because they say they're fearful of contracting COVID, the first thing that they need to identify for you is, do they have a reason to be fearful? So do they have an underlying medical condition, or do they live with someone who has a medical condition that might make them particularly vulnerable to COVID? If they do, they must provide that evidence to you in the form of a doctor's statement or clearance. At that point, you could then make other decisions about them having leave or whatever it might be. If they're not able to provide that to you, and you can identify clearly, we're providing a safe workplace, we've got hand sanitizer, we've got room numbers of people in rooms restricted, we've got social distancing in place, all of that sort of thing, then what you would be doing, I would recommend, is a disciplinary process. So invite them in, give them an option to discuss why they're not doing what they've been asked to do, i.e. come to work, and then if they don't have a good reason, then you issue them with a written warning, and you might have to do that 2-3 times. If they still are refusing to attend, then you could look at terminating, and that's what we've done a couple of times for our clients to date with these recalcitrants. And you've also, those of you who've got casuals who are on JobKeeper, again, I'd love to see a show of hands whether that's you, but if you've got casuals and receiving JobKeeper and they're refusing to come to work or refusing shifts, recommend having a chat to your accountant and or the ATO, because they're not regular and systematic anymore because they're refusing shifts. So you shouldn't be paying them JobKeeper.
Just on that, do you think it's broadly very concerning that a lot of people have just gone to a massive effort to call casuals regular and systematic to get JobKeeper, and now they're in a situation where
court decision?
You've got and now they're actually putting their hand up to say, well, actually you can come back and for the claim against me for back payment.
It's quite interesting to sort of mull on that you've got a court decision that's come out just after all of these employers have said, I've got these regular and systematic casuals, here they are. Now, can you please give them JobKeeper? Is that information then going to be used by Fair Work or just the employees themselves to say, you told me I was regular and systematic right here. So now I want my annual leave and my sick leave. So yeah, it's going to be interesting to see what happens. One thing I didn't say at the top there was that court decision is being appealed as we speak. And the government has also suggested that they will not be legislating with regard to that decision. Yeah, that all sort of remains up in the air still. But yeah, lots of concerns around that one.
Yep. Okay. Got another one here. So this is a bit of a difficult one. If I review a salary and realise it may have fallen short of rewards and legal benefits, what do I do? And they've said, keep quiet, ? Or can I make it up to them gradually?
Yeah. Good question. And look, that will be a business decision for you as a business owner or employer. what can you afford to do? And a part of that is weighing up the risk. So purely from an employee industrial relations perspective, I would say to you, the legal position is you need to make the restitution and pay them back, even if you need to put something in place to pay that back over a period of time. From a commercial perspective, you can look at, balance the risk, and that will depend on, have I underpaid one employee or have I underpaid 20 or 30 employees? And we certainly see that. And can I actually afford to make those payments? Or do I take make the adjustment now to the correct pay rate with some sort of, believable, I'm giving you a pay rise or whatever it might be, and then take the risk, knowing that you may still receive an underpayment claim at some time in the future from that employee or group of employees. And often, once one person has lodged an underpayment claim, they'll, tell their friends. And so you may get several underpayment claims at the same time. So it really is a business decision around what can I afford, what other options, what risks am I prepared to take around it.
Yep. We've got a couple of clients at the moment as well, and a couple of other businesses we've been speaking to. We actually put Lizzie in touch with one the other day, where they've had situations where employees have been either stuck somewhere in lockdown, as in they've been working on a project in Victoria, now been shut down, or they've been in a situation where they've employed somebody who's been a designated, say, sales rep for that area that can't get in there, and so that person's effectively redundant. What would your suggestions be around how people would handle a situation like that? Because it seems disturbingly common.
Yeah, and look, it is. I found myself almost in that position at the beginning of this crisis. I knew that our Premier down here was going to shut our borders, and was he going to shut them with me on that side of the state, or straight, I should say, on this side, and what that might mean. So look, if you've got employees in that situation where they may be stuck and they can't get back to work, because they're interstate, or the area that they would service, for example, is inaccessible. It's again about having our Managing Director, Ed Mallett. Some of you may have had the pleasure of tuning into Facebook Live with Ed for a couple of months back in April, May. One of the things that he talked about. So forward planning, am I going to need that person still, or can I foresee that I'm still going to need that person as we climb out of this? Or not. And if the answer is yes, I am definitely going to need them, then having a conversation with that person, consulting with them around, can they take a period of unpaid leave for whatever, the period of time might be? Do they have accrued annual leave? Can they take that, and checking each of your awards? Most awards have new updates, courtesy of COVID, where employees can now take their annual leave at half pay. So therefore they can take for, double the length of time. Or, can they work from home? Do they have a job where you can deploy them and get them working, or in another site, if not home, if they're not able to get home, for example? So there's lots of options. I would stand with Ed's thought and advice that redundancy would be my last option when you've explored all the other options available to you, but it is a reasonable option. So if you can identify, look, due to the impact of COVID or due to a restructure, we just don't have this, position anymore, and we can't foresee it happening and needing it in the next, foreseeable months or whatever, then you might look at a redundancy process. If I had $1 for every time I've said redundancy over the last few months, I could retire. So yeah, it's definitely an option.
There's another one here regarding safe COVID practices, and that is, can I enforce safe practices for COVID, or are they just recommendations, i.e. can I make employees vaccinate or sanitise? I'm guessing by vaccinate, flu shot. But I guess they've been following the Gold Coast Titans situation pretty closely, which was interesting. But what are your thoughts there?
Yeah. That's a really good question, and some of that comes back to, for example, what if you have an employee who turns up to work showing the signs and symptoms of a cold or flu, and therefore potentially COVID? Your first obligation is to provide a safe workplace. So if you've got an employee who is breaching work health safety regulations, and that's what your COVID regulations are, and take a step back, get it in writing, get a COVID or coronavirus work health safety policy in writing, which talks about things like hand washing and physical distancing and all of that sort of stuff. So if they're refusing, a la the Karens of Bunnings Worlds, to put their, to sanitize or to wash their hands or, keep social distance, all of that sort of stuff, you do have a right to enforce that. So, and the way to do that would be, again, disciplinary processes, making sure that there are consequences, I guess, for their behaviour, and how serious you take that and how far you take that will probably depend on your industry and the risk inherent to your industry, and your employees as well. And if you've got someone who's turned up to work with the signs or symptoms of a cold or flu, so we had a client talk to me the other day. This employee was insisting, I have cold symptoms, not flu symptoms. And she was insistent that it said cold and flu symptoms. So no, she just had cold, not flu. Then you need to send them home. And then I guess depending on what state you're in, but I guess particularly, if we looked at Victoria, you'd want a clearance to state that they are COVID-free before you let them back in the workplace. And I think from, what I was reading in the media yesterday, which granted, we have to be very careful about what we read in the media, that seems to be a suggestion of why the spread is as widespread as it is in Melbourne, people going to work while they have symptoms before they get tested, or while they're waiting for the test to come back. They're at work. So, yep, send them home, and require a clearance before they come back. Yeah.
I just had one more here, and that was, I think another one's popped into the chat now as well, but last one that I was sent was whether an employee can be held responsible for setting up an employee's home office. I'm guessing sort of financially, are they required to provide the equipment to do that?
Yeah.
Or is that back to the employee?
Again, first of all, a work health safety perspective, you're required as an employer to ensure they have a safe place to work at home, so that your employee needs to do a risk assessment of their workspace, and be able to, you need to be satisfied that it's, safe as possible, and depending again on what job they do. So for me, I have a terribly unergonomic chair that I sit on. It's a beautiful pink velvet chair, but it's not very ergonomically friendly. So you've got that requirement, and then to provide them the essential things that they need to have as an employee to do their job. So, is it, computer monitors, a phone, keyboards, other sort of, things like mouse pads, or, those wrist protection, all of that sort of stuff. If that's what they would normally have in the office, for example, that's what you need to provide them to work from home, because you're requiring them to do that as their workplace, at least temporarily.
Sure. And one more just popped into the Q&A as well. I'm not too sure what angle this is coming from, but are offshore permanent employees deemed as full-time employees? I'm assuming this is for reasons we've been speaking about, as in fair work and safe work.
Yeah. The easy answer to that is yes and no. And again, thank you to our courtesy of our very complicated system. It depends on how you've engaged that employee, and what their contract says as to whether they're covered under the Fair Work Act, and therefore come with all of those legislative protections, or whether you've actually engaged them under their whatever country they may be working in. Have you engaged them under that national system? And there's some very interesting, for those of you who are interested in such things, cases that have been before Fair Work over the years about that very thing. And the fact that they go before Fair Work for them to make that determination, I guess, shows how complicated it can be. So it does very much depend on your contract, and how you've got that arrangement set up.
Sure. I've just actually got one last question. I think that's everyone taken care of, but it just relates to a gentleman who was going to join today was unable to, so I asked him to send through his question. He sent it through. It was several pages, a full dossier of information. So I'm just going to give you it's very complex, but I'm just going to give you the very basics of it. So essentially, he's a prospective client we're working with. He runs a meat processing plant, and it's important to note that this gentleman's of the Muslim faith, and so is a lot of employees, and so is a lot of his customers. And he recently hired somebody. They do a lot of processed meats and things like that. He recently hired someone to process on the factory floor, and due to his Muslim faith and due to the client base and everything, all their products are halal. And he didn't stipulate that it was to be a Muslim employee because he didn't want to discriminate, and the person that he hired obviously wasn't. And then it was reported to him later by the other employees that he wasn't following any of these halal practices at all. And so obviously that's very egregious to Muslims. It was obviously very offensive to him. So he dismissed this employee on the spot. This employee said, if you do that, I'll see you in court because there's nothing in my contract saying that I have to do it in accordance with your beliefs. I'm just here to do a commercial job. You know, your religion's kind of, you know, your matter. I'm just here doing it to the best of my ability. I'm doing a very good job, and I think he was very efficient and everything else. However, if you're not happy with it, that's your problem. Due to the fact that he didn't have a contractually set out, he retained him as an employee, but obviously there's a lot of bad feeling there at the moment. So yeah, so I'm just wondering, because I guess that's the situation. But I just thought, well, that actual scenario has a lot of more universal bearings. In at what point, I guess, does something that's completely intolerable behaviour from an employee's perspective, from an employer's perspective, when does that cross the line of just being something that's just sort of based on the opinion or the values of the employer, not, sort of something that's technically illegal or bad practice?
Yeah. And look, it is highly complex, that situation and our the way that we manage terminations and whatever because of our law. But one of the questions I'd be keen to know, one of the answers I'd be keen to know with respect to that employer and employee was the employee trained and provided the information? It doesn't matter that wasn't contracted, but that, what their practices were in terms of processing the meat. I'm going to assume that they were, and that if he's then deliberately gone against those practices, then there is certainly a case for, a disciplinary based on a deliberate, what's the word looking for? Refusal to follow reasonable management directive. So he's been directed to do a certain work task in a certain way, and he's refused to do that because, for whatever reason. And then depending again on that, in terms of that matter, it may be that the employee has, deliberately ignored those instructions, and it could come down to a religious issue or a discriminatory issue, which again can be a disciplinary matter around discrimination. So, be really interested to get exactly what's happened there. But again, if he's on under the 6 months or 12 months, depending on the size of the business, and they could identify there's nothing to do with this person's religion or state, country of origin or sexual orientation or anything like that, that they are dismissing him because of his work performance or misconduct or lack of suitability for the role, i.e. he's not prepared to process the meat as they require him, then as long as they look very carefully at those adverse action risks, they could probably still look at and look at options for termination still there. Yeah, sure. Because I guess that's a long way of me saying it. Even where, let's say, flat out, and we see it on telly all the time, but in the real world it doesn't happen without great consequences. An employer punched the employer. I've seen it happen. you know, well, not personally seen it. I've dealt with the outcome. That's not, even that is not, you cannot terminate the person on the spot for that, even though it's clear what's happened. You know, there's been a physical assault. There still has to be a process followed before that employee can be terminated. And boxes ticked. Now, it may still only take 24 to 48 hours, but you can't just say on the spot, you're sacked, get out, because you most likely will get an unfair dismissal claim about not following a fair process. So there's a valid reason, but the process hasn't been followed. And you will then have that enormous pain of having to pay extra money to that person, despite their incredibly bad behaviour.
So do you think probably one of the best approaches that an employer could take in that situation, if they had, so thinking about this gentleman, but just thinking about situations generally, if they've got particular values or they've got something that's really important to them within their business, they need to, I guess, somehow work that into the workplace contract, that there's exclusions around it. Okay, this is the way we operate, and that the employer is made very well aware of that prior to. Probably particularly in like a code of conduct or something like that as well, or policy. Yeah, if there's something like that, I guess from a cultural or religious perspective, that is absolutely critical. And have it that it is in writing and that it is very clear. So I think Lizzie, you flagged it. We everything that we do in talking to our clients is document. You have to have a paper trail to be able to, because if it ends up at Fair Work assume the employee's side until you can prove differently. And you can only prove differently by having documents. It's never, it can be the employee's word, but not the employer's word. It has to be documents, that's provided for proof. That's excellent. Well, I think that's all the questions, Gwen. So thank you very, very much.
My absolute pleasure.
Yes, there's still quite a few that have stuck around to the end. So thank you very much for giving up your time. You obviously found that riveting. I definitely learned a lot. So that's great. And if obviously if you have any other questions, feel free to reach either of Gwen or Lizzie, and they're always very happy to take your questions. And the ones that have asked for Lizzie to get in contact with them, no doubt she will shortly. But no more questions. I would say that everything's crystal clear. There's no more questions about HR at all. I think everyone's expert.
It's done.